One.
This Honorable Supreme Court of Tennessee is now in session.
Thank you, Mr. Hibner. Good morning again, ladies and gentlemen, those of you that are counsel that are with us directly. Again, we also welcome those of you that are watching our proceedings today by live stream on YouTube. As I mentioned before our first case, this is the June 2021 docket of the Tennessee Supreme Court. We have been conducting our oral arguments by way of Zoom for the last several months as a way to deal with the pandemic, to keep our justice system moving, as well as protecting the health and safety of our folks in the court system and our general public. So we appreciate the ability and the participation of the lawyers here. And for those of you that are watching on YouTube, we hope that you will use this opportunity to learn a little more about our judicial system in the state of Tennessee and about the justice system as a whole. In just a moment, we will begin this second case. When we do, each side will have 30 minutes to argue their side. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. All right, Mr. Hibner, if you'll call our next case, please.
State of Tennessee versus Urshawn Eric Miller.
Mr. Epperson, let me say preliminarily, the court very much appreciates the efforts that you have made in stepping in as counsel in this case and for doing the representation that you have done so far, and we appreciate your argument here today.
Thank you, Chief Justice. Good morning. I would like to reserve 5 minutes for rebuttal.
All right.
I am Jeremy Epperson. I'm the public defender here for the 26th Judicial District. My office, or our office, did represent Mr. Miller at trial in this matter, and also at the intermediate level of the appellate court, the Court of Criminal Appeals, and we continue to represent him here today. I want to make sure I give credit where credit's due. Mr. George Goose, my predecessor, and Mr. Gregory Gookin, who was an assistant public defender, also represented Mr. Miller at the trial court level and at that Court of Criminal Appeals level as well. Mr. Miller was convicted of, after a trial, first-degree murder, felony murder, attempted second-degree murder, attempted especially aggravated robbery, aggravated assault, employing a firearm in commission of a dangerous felony, resisting arrest, and evading arrest. I believe there was another count that was ultimately dismissed after the jury returned its verdict. I believe that count was convicted felon in possession of a firearm. Ultimately, on the first-degree murder count and the felony murder count, Mr. Miller received a sentence of death. Just a brief summary of the facts of the case. Proof introduced at trial established that the subject entered a business known as, referred to as Bull Market, I believe, in the area of Hollywood Boulevard and Arlington Avenue here in Jackson, Tennessee. This subject demanded some money or some property from the attendant there at the cash register of that business. Appeared to fire some type of a warning shot upon, or maybe sometime after making this demand for property, and then again fired a second shot, which then struck the victim, who was identified as Ahmad Dali. After the subject attempted to retrieve some property, fired toward the general direction of another employee who was identified as a Lawrence Austin. The subject then, shortly after that, left this business, this store, this Bull Market. And then shortly after that, multiple officers of the Jackson Police Department arrived on the scene. There's a lot of testimony from various officers that reflected that they went to search the general area known as Lions Field, which eventually led to the capture of the appellant, Mr. Miller, in this case. It's a personal aside. Going back to Lions Field, for those that don't know that, that's a little league ball field here in Jackson. I actually had some childhood memories of that myself from playing little league baseball. So I was able to visualize that and remember back on those childhood days when I saw the Lions Field. But I digress. There was some additional proof that was submitted regarding some items that were found at Mr. Miller's residence. and also some additional evidence that was recovered. I believe some personal items, or maybe even the actual weapon that was found in the area of Lyons Field, and some testimony and some proof submitted based on the nexus between those items and Mr. Miller. Today here, what I'd like to discuss and argue really is whether Mr. Miller was afforded a fair trial. And we submit that he was not afforded a fair trial, as illustrated by the errors that occurred during voir dire. And also we submit that the trial court erred in submitting a video of a prior offense of Mr. Miller that was substantially similar to this case. That prior offense involved aggravated robbery of another convenience store some years prior to this. So first off, I think we can all agree that the Tennessee Constitution and federal Constitution guarantee defendants the right to a fair trial. And part of that during voir dire, that allows not only the trial court, but also the parties an opportunity to ensure that jurors are competent, unbiased, and impartial. That was recognized back in this court's decision, State versus Howell. And first, I'll discuss there's a group of jurors that were removed for cause at the state's request. Specifically, it was John Eads, Grace Milhorn, and I believe a Miss Melanie Sesty. And during voir dire, Mr. Eads appeared to be kind of conflicted with the issue as far as when he's confronted with whether or not he would want to impose the death penalty. I think it would be reasonable for somebody to express some hesitation when he's faced with that particular issue. But ultimately, he indicated that he could consider all forms of punishment, that being life without parole, and the death penalty. And he could do that regardless of his personal views on the death penalty. Miss Milhorn, she indicated she had a preference. Her preference would be life without parole, not the death penalty, but that she thought the death could be appropriate in some cases. Nevertheless, she said that she could vote for the death penalty if the state had met its burden of proof and proved its case. And then Miss Melanie Sesty, I think her answers varied based upon each specific hypothetical situation that was brought up, that was presented to her. But she indicated she could also consider all forms of punishment and follow the trial court's instructions, and the jury instructions as it pertained to the sentence in this case. So,
Mr. Everson, this is Justice
Yes.
Page. Does the record reflect here during jury selection whether or not the state ran out of peremptory challenges?
I believe somewhere in the transcript, I think that was. If I'm incorrect there, I apologize, but I think there was somewhere when I reviewed everything, I thought that was brought up somewhere. I know I saw it somewhere. I don't want to say I just saw it in passing or having a conversation with counsel that was previously representing Mr. Miller, but I believe it was. I don't believe they used all their peremptory challenges.
I guess my point is, if now my cell phone's ringing and my office phone is ringing, so I put this thing on mute. I promise I did. Yeah, it's ringing on. Okay, I don't know how that happened. I have to talk to Cellular about that. But,
Justice Page, it's a good thing you're not a lawyer arguing this case, or it might come down on you.
well, now I couldn't help the office phone ringing, Justice Lee, but my personal phone, I'll take responsibility for. Back to my question. The point is, you're challenging the fact that the state was granted cause on these jurors, but if they weren't out of peremptory challenges, it doesn't make any difference, correct?
If they were, they could have exercised a peremptory challenge. So yes, but they didn't have to. So I guess they could have been forced with that decision whether or not to use one or not, but they were never faced with that decision.
All right.
Mr. Everson, I've got a question on on
Yes,
that
ma'am.
issue. You're challenging the trial court's ruling as to these jurors that were challenged for cause. And it might make a difference as to which appellate standard of review that we use in reviewing that trial court's decision. What do you think, what standard of review should we use in reviewing the trial court's decision as to those jurors for cause?
I think the case law reflects, forgive me if I'm wrong, but I believe the case law reflects that's an abuse of discretion, and there needs to be, there also has to be some, I don't want to call it manifest injustice, something that's manifest there that occurred to reverse the trial court. But I
If
believe
the standard is abuse of discretion, you say you should succeed, understand. But if it's a higher standard, that is that we presume the trial judge is correct unless the appellant, the defendant in this case, establishes by convincing evidence that the judge was in error. Do you think you still prevail if we apply that higher standard? In other words, did you show by convincing evidence that the determination was in error? Do you think?
I would say that we should prevail on that, because I think based on the jurors' own words that they could set aside personal feelings. They could follow the court's directives and their instructions. They could follow the law and follow the jury instructions, and they should not have been removed for cause.
Well, to follow up on Justice Lee's question, we have cases that say both standards prevail. Some cases talk about abuse of discretion. The Alley case from 1989 uses the standard that Justice Lee just told us. So should we use this case to determine what the standard should be?
Yeah, I think this would be a good opportunity to establish that, Justice Page, based on that. Yes, sir. If there are not any follow-up questions, I'll move on. That brings me to the next list. There were several jurors who were not removed for cause at the defendant's or the appellant's request. Those include Mr. Ronald Robinson, a Miss Melissa Little, and a Miss Joan Graves. Mr. Ronald Robinson, he used some language about, he believed something about an eye for an eye, some additional language that he believed that there's taxpayers' money shouldn't be spent on the upkeep of prisoners if they were given a sentence of life or life without parole. He also indicated that if a defendant was of sound mind, that they should receive the death penalty. And with respect to Mrs. Melissa Little, she talked about her brother. Her brother had worked for the district attorney's office here in Jackson. Her husband was a retired officer with the Jackson Police Department, and she indicated, she'd be inclined to give a death penalty unless there was some issue of self-defense. We would just submit that if it was an issue of self-defense, I think that was even pointed out there in voir dire, that would not be first degree murder or felony murder. And with respect to Miss Joan Graves, she indicated that she was very familiar with the prosecutor. I think she said that I think she had 3 daughters that went to high school or grade school, maybe all the way throughout, went to school with the prosecutor. And she indicated that she would be very much trusting of the prosecutor. She had some issues. She might have some struggle, viewing evidence like photographs and video. And ultimately, she did say she was inclined to vote for the death penalty. So, based on all both circumstances, we would submit that each one of those particular jurors should have been removed for cause. They were not removed for cause, and the defendant believed he did exercise a peremptory challenge as to each and every one of those particular jurors. And then finally, it brings me to Miss Drew Crum. She was examined in voir dire, and she indicated that she would not consider a life sentence. I would submit at all. She placed an impossible standard on Mr. Miller he would, in order to get something less than death, I think that he would have to prove his repentance, or that I think, quote unquote, he would have to show that the Lord got a hold of him. At that point in time, I believe that she was requested to be removed for cause. She was not. And also at that point, the defendant had exhausted all his preemptory challenges. So he was left with Miss Crum serving since she was not removed for cause.
Are you saying she was requesting to be removed for hardship?
No, just based on her personal views. I think she was requested to be removed for cause. It's based on her. She would not consider a life sentence, and also based on her, I think it's basically her religious views as it related to the death penalty. So for all those reasons as regarding voir dire and the jury selection, we submit that Mr. Miller did not receive a fair trial based on those errors that occurred during voir dire. Finally, that brings me to second issue, and that is this video that was introduced during Mr. Miller's sentencing during the sentencing phase of the trial. This video apparently it portrayed Mr. Miller in a prior aggravated robbery that occurred some years prior to this at a different convenience store. I believe it was on Riverside Drive. I believe at the intersection of Riverside Drive and Steam Mill Ferry Road in South Jackson. I believe the video was introduced pursuant to Tennessee Code Annotated 39-13-204C. I concede that particular statute, the language of that statute grants trial courts some great discretion on the admissibility of evidence at a sentencing of a capital case. If you look at the kind of plain language, it almost seems like almost any evidence could be utilized. However, I believe that this court has addressed the issue and indicated that that discretion is not unfettered. In other words, that there are limits to what can come in to evidence despite the plain language of the statute. In that case was State versus Sims, which is a 2001 Tennessee Supreme Court case. We would submit that trial courts are still required to examine proposed evidence for reliability, relevance, value, and prejudicial effect. I believe that comes from this Sims case, as in addition to a Court of Criminal Appeals case from August 18, 2016, State versus Clayton. And I believe there's been a lot of case law out there saying that the court has long discussed the possibility that photos and videos have a prejudicial effect.
Mr. Epperson, this is Justice Clark. And if I may ask you a question, because you've been talking about several different things, but on the question of prejudicial effect, doesn't the statute itself specifically remove that from consideration? And doesn't it say specifically that it shall not be subject to exclusion on the ground that the probative value is outweighed by prejudice? It
does state that, Justice Clark. The plain language does do that.
Been overturned. I mean, aren't we bound by that? There are a number of determinations a court can still make. I agree with you, but I'm not sure that the outweighed by prejudice one is permitted under this specific statute. So talk to me about that.
The statute does say that. However, again, I revert back to this court has said that discretion is not unfettered. I think sometimes, especially in a death penalty case, there's a higher heightened due process that comes into play. And I think that there's other ways to get, I think that's what we're arguing in this particular case. There's other ways to get, anytime the state puts on evidence, there's some prejudicial effect to it. But I think in this particular case, what we're arguing, and I think what occurred at the trial court level, is that the defendant, the appellate, conceded that, or even was willing to stipulate that prior aggravated robbery conviction, and was even was willing to stipulate to that his prior confession could be introduced at the sentencing during the sentencing phase of this.
I think that's right. But is there any statute or case law that requires that if he says, I will stipulate to a certified copy of the judgment, that the state is prohibited from offering other evidence?
Only thing that I can think of by analogy, something I've done in practice myself is I think there's some case law out there in something of less seriousness, a case that involves convicted felon in possession of a firearm. Sometimes when possession is the only issue that's being contested, the defendant can stipulate to his prior conviction, and I believe the state is bound to that stipulation. I believe there's some case law to that effect, and I would think that's something by analogy that could apply here. Especially when there's in light of a stipulation to that additional proof, because what concerns me, what concerns the defendant, the appellate, Mr. Miller in this case, is inflaming the passions of the jury, having them make a decision based on emotion rather than logic and reasoning. So we try to, in order to promote that fairness and make sure that they do that.
Mr. Epperson, this is Justice Page. I just want to make sure for the purposes of the record, this video is in the record, correct? The one you're referring to in this argument?
Yes, it was. It was submitted in evidence. That's correct.
Okay. And back to your questions about the jurors. In preparing for this, I realized that the juror questionnaires are not in the record, but the parties read from them extensively during jury selection. So it's your position that the record is sufficient as to those issues. Is that correct?
That's correct, Justice Page.
Okay.
Mr. Epperson, is it correct that at one point you or perhaps one of your predecessor attorneys filed a motion to supplement the record with all those, but that this court denied it?
I believe that is correct. I believe it was Mr. Gregory Gookin who was handling the matter before I became involved. I believe he did file a motion to supplement those questionnaires.
Okay, but it's your position today that because they were read extensively, they don't physically have to be present in the file?
That's correct. I think the court and even myself I was able to rely sufficiently on the transcripts that were provided. I believe that I've addressed everything that I have wanted to address today. So just in conclusion, just say other issues that I didn't argue here today, we would rely upon the brief that I believe those issues have all been addressed sufficiently in the brief. So we would submit those on brief. And just say that Mr. Miller requests, based on everything, all the circumstances, he requests a verdict of dismissal, modification of his death sentence to life or life without parole, or in the alternative to grant him a new trial.
Thank you, Mr. Epperson, very much. All right, Mr. Spangler.
Good morning, Your Honors. May it please the court, Nick Spangler for the state of Tennessee. I'll generally limit my argument to address the issues addressed by Mr. Epperson, but I want to start by addressing a couple of questions that the court had. I'll start with this jury selection issue in the record. I believe in the Court of Criminal Appeals, Justice Page, the record was supplemented with the peremptory strikes. That was not something that it was initially in the record in the Court of Criminal Appeals, but then I believe before oral argument, the record was supplemented with those peremptory strikes. I'm sorry, I do not recall whether the state exhausted all of its challenges, but I believe it was established that the defendant did exhaust all of his challenges, because there was a slight change in my brief. When I briefed it in this court, I had made some arguments in the CCA based on some lack of clarity about whether the defense had exhausted their peremptory challenges, but I believe that they did. And Justice Clark, I believe that is correct. I think there was an earlier motion to supplement in this case before this court to supplement with the questionnaires, and the state responded in opposition to that. One, because I think we're in general agreement with Mr. Epperson that the record is adequate because those questionnaires were referred to during voir dire sufficiently. And also, we just submit, we think it's improper to include those before this court, because that's not something that the Court of Criminal Appeals had the benefit of reviewing in making a decision on these jury selection issues. Beyond that, I'd like to address your question, Justice Lee, about the standard of review in this case. And so the question about, establishing by clear and convincing evidence that the court's determinations were erroneous, I think that actually harmonizes with the abuse of discretion review that applies to this issue. I think it is abuse of discretion. How establishes that, the how decision states that. And I think when you talk about abuse of discretion, one of the ways it can be established that a court abuses its discretion is it bases its decision on clearly erroneous assessment of the evidence. So I think that language that we cite from the Smith decision about, rulings on challenges for cause and the defendant having to establish by clear and convincing evidence that the court's determinations were erroneous, I think that language speaks to sort of undermining the evidence or the facts that went towards the trial court's overall ruling on the challenges for cause issue, if that makes sense. I think that goes to, I think that's kind of the standard that applies to factual determinations by the trial court, but on the legal question of whether or not the court correctly ruled on the question of cause, I think that is reviewed for abuse of discretion.
But Mr. Spangler, this is Justice Bivens. Well, but based on that, would you all not agree with opposing counsel that this is probably a case where the court needs to clarify what the appropriate standard is here?
I think that would be appropriate. I mean, I think it is pretty clear under the Howe decision that challenges for cause are reviewed for abuse of discretion. But I think sort of doing something to explain how that harmonizes with that other language about clear and convincing evidence would be helpful, because it is something that I had to spend a little bit of time thinking about before argument and during briefing to sort of understand how that harmonizes. I think there's also actually a question about when you talk about a fair pool of jurors, or that you had a fair and impartial set of jurors that decided your case. That's actually probably a constitutional question, which may be subject to de novo review, separate and apart from the abuse of discretion standard that applies to the ruling on the challenge for cause. And to explain that, I think, for example, a court could rule that overrule a challenge for cause, but then and be incorrect, abuse its discretion in that ruling, but then that particular juror be stricken by peremptory challenge. And so there's no constitutional violation because there's not an unfair or impartial jury, because that particular juror didn't end up on the jury, but there could still be that abuse of discretion on the ruling for cause. So hopefully that makes sense. But I think those are sort of separate, discrete questions. The
Mr. Spangler, this is Justice Page. I think I'm more confused now than before I came in here with respect to this.
Sure.
I'm looking at the Alley case from 1989, and the quote is, the trial court's finding of bias of a juror because of his or her views of capital punishment shall be accorded a presumption of correctness, and the burden shall be on the appellant to establish by convincing evidence that the determination was erroneous. That seems to me to be a higher standard than abuse of discretion. Are you saying it's swallowed up in the abuse of discretion standard somehow?
I think it is swallowed up on the abuse of discretion standard, because I think a ruling on a question of bias is essentially a factual finding that a given juror has bias, which sort of factors into the ruling on whether or not factors into whether or not the decision on the challenge for cause is correct. But I think that's a factual question that the defendant has to overcome by clear and convincing evidence, and then that informs the abuse of discretion question as to whether or not the ruling on the challenge for cause was correct. Okay. Hopefully I'm not confusing it more.
Process.
I'm sorry, I couldn't hear you, Justice Lee.
Are you saying it's a two-step process? Review the factual finding, and then based on that review, you review the legal decision?
Correct, Your Honor. Correct, Your Honor. And I think it factors into that, from the Mangrum decision, we talk about sort of three different ways a court can abuse its discretion. And that third way is bases its decision on a clearly erroneous assessment of the evidence. So if a trial court clearly erroneously assessed a factual question of bias, then it has abused its discretion on ruling on the challenge for cause. Hopefully that makes sense.
Well, I think so. I wondered, as I read that, I wondered how an appellant, which I suppose would be a defendant, could establish by convincing evidence that the factual finding was wrong. I mean, you don't typically introduce evidence when selecting a jury. I just wondered how that plays out in real life.
I think it would have to be limited to basically the jurors' responses during voir dire. I mean, if a trial court just totally ignored certain responses or just misunderstood certain responses, I think it could be a clearly erroneous assessment of the evidence in that regard. But I do think it does have to be tremendously deferential because that factual question of bias does so heavily depend on the trial court's ability to assess the juror's demeanor. I mean, it's like any other factual question or credibility determination that we normally defer to at the trial court. So I think it is possible, but I do think it is rare and it's going to be difficult in most cases.
Okay, thank you.
So those are the questions that I wanted to address at the outset, and now I'll just kind of move on to addressing each one of these jurors. Under this abuse of discretion standard, we submit that the trial court acted within its broad discretion in ruling on several of these motions to remove potential jurors for cause. First, we submit that the record includes substantial evidence that the trial court did not preclude a fair jury by refusing to remove Mr. Robinson, Ms. Little, and Ms. Graves for cause. The record of voir dire of these potential jurors showed that they would follow the law and serve impartially. For example, Mr. Robinson repeatedly confirmed that he would fairly consider all three sentencing options available for first-degree murder. Ms. Little, she admitted a familiar relationship with some people serving in law enforcement, but she confirmed that as a result of that relationship, she didn't know anything about this case, and she also repeatedly promised to fairly consider all three sentencing options for first-degree murder. And then similarly, Ms. Graves, she confirmed that her acquaintance with the prosecutor and prior jury service would have no effect on her consideration of this case. And she also, like the others, promised to fairly consider all three sentencing options for first-degree murder. We submit the record also includes substantial evidence that the trial court didn't preclude a fair jury by actually removing Mr. Eads, Ms. Milhorn, and Ms. Sesty for cause. Again, the record of voir dire, we think, showed that these potential jurors would not follow the law and could not serve impartially. Mr. Eads, for example, expressed a very strong aversion to the death penalty, saying that it should never be imposed, that he would never impose it, and that actually he wouldn't even fairly consider that form of punishment. Ms. Milhorn's jury questionnaire responses, and again, this is all based on discussion of the questionnaire responses rather than a record of those since they're not in the record, but her questionnaire responses indicated that she could never return a death verdict. And when she was asked about those questionnaire responses, she confirmed that she couldn't impose the death penalty and would also just disregard it. And then Ms. Sesty, she equivocated some about the death penalty initially, but ultimately admitted that she probably could not fairly consider that form of punishment based on her religious beliefs. And she also eventually expressed her view that the death penalty should never be imposed. And then finally, the record includes substantial evidence that the trial court didn't preclude a fair jury by refusing to remove Ms. Crum for cause. And this is a good opportunity to say that, again, Ms. Crum was actually the only one of these potential jurors that actually served on the jury. All six of these other prior jurors that we're talking about were either removed by way of peremptory challenge or removed by the trial court, which, going to the harmless error analysis of this question, you really can't establish a basis for relief given that none of those jurors actually ended up on his panel. But with regard to Ms. Crum, voir dire showed that she would follow the law and serve impartially. She emphasized that the evidence would be her primary guide in making a sentencing decision. And her concern with repentance was not inappropriate. It sort of coincided with the law's recognition of remorse as an appropriate mitigation consideration. And she also promised, like the others, to fairly consider all three forms of punishment for first-degree murder. So given all this, we submit that the trial court acted within its broad discretion on ruling on these various motions to remove potential jurors, and the defendant was not denied a fair jury. Unless there are any questions about that issue, I'll move on to talk about the second issue that Mr. Epperson discussed, and that is we submit that the trial court acted well within its broad discretion during sentencing when it admitted the video of defendant's prior aggravated robbery that served as proof of the prior violent felony aggravator. And really our argument on this is very simple and based on statute. And that is in 1998, the legislature amended 3913-204C to specifically allow during capital sentencing hearings evidence concerning the facts and circumstances of the prior conviction used to establish the prior violent felony aggravator. Since that amendment, this court has repeatedly affirmed the admission of such evidence under that code section. And based on that, we submit it was entirely appropriate for the court to admit that video in this case during this capital sentencing hearing. I'm happy to answer any other questions the court may have about these issues or any others. Otherwise, we just respectfully ask that you affirm the decision of the Court of Criminal Appeals and affirm the judgments of the trial court. Thank you.
Thank you, Mr. Spangler. Mr. Epperson?
Forgot to unmute myself there. I apologize.
That's all right.
Main thing I wanted to emphasize during this time is with respect to the admission of that video during the sentencing phase of the trial in this matter. Despite the language of the statute, that statute cannot circumvent a defendant's right to a fair trial. I think part of having a fair trial is the proper admission of evidence. In this particular case, although the statute says that you don't consider the probative value versus prejudicial effect, I think that that's still under the defendant's right to fair trial. I think that you still do that.
Mr. Everson, this is Justice Clark. Does it make a difference that this, in this case, appears in the sentencing phase and not in the penalty phase? Often when we are looking and considering the admission of these kinds of pieces of evidence, we are thinking about, will seeing something like this or something similar this defendant has done cause people to be more likely to think he's guilty. In this case, the jury heard all of the proof and adjudicated guilt before they got to sentencing. Does that make this any different?
I think since it involves a sentence of potential death, and then he received the death penalty in this particular case, I think it does make a difference. I think there's that heightened due process standard because of that. I think that you still want a jury to make a decision based on logic, reason, as opposed to emotions like fear or anger, retribution, things of that nature. So based on that, I think even though that statute the language of that statute authorized the admission of that evidence, I don't think, based on all the circumstances that we've argued, I don't think that it was proper for that video to be admitted into evidence. With that, we again request unless there's any questions, I'll conclude with that.
Mr. Epperson, this is Justice Page. I want to ask one question about the video. Other than it showing this defendant committing a robbery 8 years earlier with some co-defendants, is there anything particularly prejudicial about it?
It's almost the exact same thing he was just on trial for, coming in to rob a convenience store. It's the exact same type of business, exact same type of conduct. So just based on that, I think even the state's argument during closing even made reference to it being the same conduct and him going too far, some language to that effect, and that kind of just illustrates more that they were trying to inflame the passions of the jury.
All right.
How is that unfairly prejudicial? To point that out. Because
there's other ways to introduce that evidence that was stipulated by the defendant. You can still do that without the danger of inflaming those passions of the jury. We can introduce the judgment. You can even utilize the defendant's confession of that prior offense.
And does that make? I'm trying to figure out how it makes it unfair prejudice. The video brings it home more. But how is that unfair in this situation?
Because from my position, it would be that there's an inherent danger that you would be appealing to the fears or emotions of the jury as opposed to really relying just on the evidence of the actual conviction itself. And you can introduce that through the judgment and through that prior his confession of the commission of that offense.
Thank you.
With that said, I'll yield the remainder of my time.
Thank you, Mr. Epperson. We do appreciate both counsel here today in arguing this case. We appreciate those of you that have been with us on YouTube to listen to this case. And this does conclude our June 2021 docket. So at this point in time, Mr. Hivner, if you'll please adjourn court.
This honorable court is now adjourned.